Committee is resumed.
The Utility, Regulatory and Competition Bill 2016. Clause 1, short titling commencement.
The question is that Clause 1 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 1 now stand part of the bill.
Clause 2, interpretation.
Honourable Member, there's an amendment being proposed there too. Yes, sir.
Thank you, Madam Chair. Madam Chair, because I'm going to have to repeat this very often, may I just simply say under the relevant standing orders? Thank you very much. Under the relevant standing orders, I beg to move following amendment. First of all, Madam Chair, that the bill be amended as follows. A, in Clause 2, subsection 1, Roman numeral 1, in the definition of the words covered services, by deleting the word sectoral participant and substituting the word sectoral provider. 2, in the definition of the words executive director of energy, by deleting the words section 28 subsection C as the executive director of energy and utilities, and substituting the words section 29 subsection 1B as the executive director of energy. 3, in the definition of the words executive director of information, by deleting the words section 28B as the executive director of information and communications technology, and substituting the words section 29 subsection 1A as the executive director of information. And 4, in the definition of the words utility services, by deleting the words sectoral utility and substituting the word sectoral provider. B, or should I stop there now because we're going on to Clause 3? Thank you.
The amendment has been duly moved. Does the Honourable Minister or any other member wish to speak to the amendment? If not, the question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 2 as amended now stand part of the clause. The question is that Clause 2 as amended now stand part of the bill. All those in favor, please say aye. Against, no. The ayes have it. Clause 2 as amended now stand part of the bill.
Clause 3, application.
Honourable Minister, there's a proposed amendment to Clause 3.
Yes, yes, Madam Chair, thank you. Madam Chair, under the relevant standing order, I move that in Clause 3, we delete subclause 1 and substitute the following subclause. 1, in the exercise of its functions and powers, the office shall not derogate from the terms and conditions of any license, authorization, or agreement in force without the consent in writing of the licensee or authorized holder, comma, subject to any special conditions concerning the modification in the relevant license, comma, authorization, or agreement.
The amendment has been duly moved. Does the mover or any other member wish to speak to the amendment? If not, I put the question that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 3 as amended stands part of the clause. I put the question that Clause 3 as amended now stand part of the bill. All those in favor, please say aye. Against, no. The ayes have it. Clause 3 as amended now stand part of the bill.
Clause 4, establishment of the Utility Regulations and Competitions Office. Clause 5, use of seal and authentication of documents.
Question is that clauses 4 and 5 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 4 and 5 now stand part of the bill.
Clause 6, principal functions of the office.
Honorable Minister, there's a proposed amendment, clause 6.
Thank you. Madam Chair, I move that the bill be amended as follows. A, in clause 6, Roman numeral 1, in subclause 1B, by inserting after the word promote the word appropriate, and 2, in
That's right, he's doing it. Go ahead, Minister.
That's why I prefaced what I said, first of all, by asking to ensure that I did them in sequence, and I thought I was doing this right for once. All is happening, Madam Chair, so that everybody understands, is there are 2 sets, but in doing so, the 5th member from Georgetown moved or asked for 2 amendments to be made, and while they were late and the rest had come down already, one of them comes before the next one that you would read on the larger sheet with the committee stage amendments. So continuing. In subclause 1B, just to go over it, by inserting after the word promote the word appropriate, and in subclause 1C, by inserting after the words to protect the words short and long term. Madam Chair, in subclause 1C, Roman numeral 1, by deleting the words sectoral utility and substituting the words sectoral provider. In subclause 2, by inserting after the words in performing its functions, the words and exercising its powers. And 3, and Roman numeral 3, in subclause 3, by inserting after the words performance of its functions, the words or the exercise of its powers.
The amendment has been duly moved. Does any member wish to speak to the amendment? If not, the question is the amendment stand part of the clause. All those in favor, please say aye. Against, no. The ayes have it. The amendment stands part of the clause. The question is now that clause 6 as amended stand part of the bill. All those in favor, please say aye. Against, no. The ayes have it. Clause 6 as amended stand part of the bill.
Clause 7, duty of counsel. Duty to counsel.
Honorable Minister, there's a proposed amendment. Clause
Yes,
7.
Madam Chair. In clause 7, I move that in subclause 2D, we delete the word and insert after subclause 2D the following paragraph. D, small a. Guiding principles setting out how the office will consider comments received and how it will publish its reasons for its decisions after it has considered those comments, semicolon, and. In subclause 3, by deleting the words likely to be. In subclause 3, by deleting the word can and substituting the words is likely to. And in subclause 3, by deleting paragraph B and substituting the following paragraph, new B, a significant impact on a sectoral provider, semicolon, or. And by inserting after subclause 3 the following subclause, 4, where the office intends to issue an administrative determination, the office shall A, give written notice of that intention to any person with sufficient interest or likely to be affected by the proposed determination, semicolon, and B, afford that person an opportunity to make written representations to show cause why the office ought not to make such a determination.
Does any member wish to speak now that the amendment has been moved? If not, I put the question that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stands part of the clause. Question now is that clause 7, as amended, now stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 7 as amended, now stand part of the bill.
Clause 8, duty to publish.
Put the question that clause 8 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 8 now stands part of the bill.
Clause 9, information gathering powers.
Honorable Minister, this is the proposed amendment to clause 9.
Yes, Madam Chair, thank you. Madam Chair, I propose the following amendment in clause 9. 1. In subclause 1, by inserting after the word functions, the words or exercising its powers. 2. In subclause 2, by inserting after paragraph C, the following paragraph. C, small a. The purposes of part 12, semicolon, close quotes, semicolon. And 3, in subclause 4, subsection B, by inserting after the word functions, the words or the exercising of its powers.
The amendment has been duly moved. Does any member wish to speak to the amendment? If not, the question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 9 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 9 as amended now stand part of the bill.
Clause 10, notification of contravention of information requirement. Clause 11, penalties for contravention of information requirements. Clause 12, cabinet may give general directions.
Question is that clause 11 and 12 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. Ayes have it. Clauses 11 and 12 now stand part of the bill.
Clause 13, board of directors.
There's a proposed amendment to clause 13, Honorable Minister.
Thank you, Madam Chair. Madam Chair, I move the amendment in clause 13, 1A, by seeking to delete the words regulatory duties and substituting the words functions and powers.
The amendment has been duly moved. Does any member wish to speak? If not, the question is that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 13 as amended now stand part of the clause. The question is that clause 13 as amended stand part of the bill. If no one wishes to speak, then clause 13 as amended now stand part of the bill.
Clause 14, structure of board.
The question is that clause 14 stand part of the bill. All those in favor say aye.
Aye.
Against, no. The ayes have it. Clause 14 stands part of the bill.
Clause 15, the chair.
There's a proposed amendment to clause 15, Honorable Minister.
Thank you, Madam Chair. Madam Chair, I move under the relevant standing order that clause 15, subsection 5, be deleted from this clause.
The Amendment has been moved. If no member wishes to speak, I'll put the question that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. Ayes have it. The amendment stands part of the clause. And now put the question that clause 15, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 15 as amended, now stand part of the bill.
Clause 16, the deputy chair. Clause 17, duties of chair and deputy chair. Clause 18, appointment of non-executive members. Clause 19, reappointment of non-executive members. Clause 20, tenure of office. Clause 21, resignation. Clause 22, revocation of appointments. Clause 23, procedure in meetings. Clause 24, disclosure of members' interests. Clause 25, remuneration board and committee members.
I put the question that clauses 16 through 25 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 16 through 25 now stand part of the bill.
Clause 26, the risk and audit subcommittee.
There's a proposed amendment to clause 26, Minister.
Thank you, Madam Chair. Madam Chair, I move in clause 26, subsection 2, that we delete the word and appearing at the end of paragraph A. Let me repeat that. I think I said and too many times. By deleting the word and, Madam Chair, appearing at the end of paragraph A, and by inserting after paragraph A the following paragraphs. Double A, not have a personal or pecuniary interest, direct or indirect, in a sectoral utility. A, B, not have been adjudged bankrupt. A, C, not have been convicted in the islands or elsewhere of any offense involving dishonesty or fraud or any other offense that is likely to bring the office into disrepute, semicolon. A, D, not to be otherwise, or not be otherwise able, rather, or unfit to discharge the functions of a member.
The amendment has been duly moved. If no member wishes to speak, I'll put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stands part of the clause. Question now is that clause 26 as amended now stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 26 as amended now stand part of the bill.
Clause 27, committees. Clause 28, appointment of chief executive officer. Clause 29, executive members. Clause 30, chief executive officer and executive directors. Clause 31, secretary. Clause 32, power to employ staff, etc. Clause 33, financial year. Clause 34, financial procedure. Clause 35, borrowing powers. Clause 36, advances, grants, and guarantees. Clause 37, payment of advances. Clause 38, reserve funds. Clause 39, balancing of reserve account. Clause 40, accounts and audit. Clause 41, annual plan and annual budget. Clause 42, performance audit. Clause 43, publication of accounts and annual report.
The question is that clauses 27 through 43 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 27 through 43 now stand part of the bill.
Clause 44, officers' power to determine that a licensee has significant market power.
There's a proposed amendment to clause 44, Honourable Minister.
Thank you. Madam Chair, I move that in clause 44, the following amendments be put into effect. 1, in the marginal note, by deleting the word licensee and substituting the words sectoral provider. 2, in subclause 1, by deleting the words "an authorization holder or" and substituting the word "a." 3, in subclause 3, subsections A to D, by deleting the word "licensees," that is with an apostrophe S, and substituting the words "sectoral providers" with an apostrophe S, and in subclause 4, by deleting the words "licensees" and substituting the words "sectoral providers."
The amendment has been duly moved. If no one wishes to speak, I put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stand part of the clause. The question now is that clause 44, as amended, stand part of the bill. All those in favor, please say aye.
Aye. Aye.
Those against, no. The ayes have it. Clause 44 is amended, now stand part of the bill.
Clause 45, conditions on significant market power licensees.
Honorable Minister, propose amendment to 45.
Yes, Madam Chair. In clause 45, we seek to make the following amendments. 1, in the marginal note and in subclauses 1 and 3, by deleting the word "licensees" and substituting the words "sectoral providers." 2, in subclauses 1, subsections B and C, 2, subsections A, B, and D, 3, subsection B, 4, 5, 6, and 7, by deleting the word "licensee" wherever it appears and substituting the words "sectoral provider." And in subclause 1B, by deleting the word "licensees," that is with an apostrophe S, and substituting the words "sectoral providers" with an apostrophe S, and by inserting after subclause 7 the following subclauses. 8, on the date of commencement of this law, the obligations of a licensee that are set out in regulations pursuant to sectoral legislation or as license conditions shall apply until such time as a licensee is determined to be a significant market power licensee pursuant to section 44, subsection 1. 9, significant market power does not apply to a sectoral provider who holds a license to provide utility services in an exclusive service area.
The amendment has been duly moved. If no member wishes to speak, I'd put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 45, as amended, stands part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 45, as amended, now stand part of the bill.
Clause 46, shares of licensee not to be issued or transferred without approval of the office.
Honorable Minister, propose amendment.
Thank you. Madam Chair, I would seek to have an amendment in clause 6, which will cause subclause 1 to be deleted and to substitute the following subclause. 1, a licensee that is a company, open brackets, other than a company referred to in subsection 5, shall not issue shares, and a person owning or having an interest in shares in the licensee shall not transfer, otherwise dispose of, or deal in those shares or that interest where the insurance, transfer, disposal, or dealing would thereby result in a total shareholding or total voting rights by the person acquiring the shares or voting rights by the issuance, transfer, disposal, or dealing of more than 10% of the issued share capital or total voting rights of the licensee, without the prior written consent of the office whose consent shall not be unreasonably withheld. But the office may refuse to give its consent where, among other things, it considers that the giving of the consent may result in a lessening of competition in the operation of networks or the provision of utility services.
The amendment has been duly moved. If no member wishes to speak, I'll put the question that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment now stand part of the clause. The question now is that clause 46 as amended stand part of the bill. All those in favor, please say aye.
Aye. Aye.
Against, no. Clause 46 as amended now stand part of the bill.
Clause 47, office to regulate changes in control of relation to licensee. Clause 48, change in control. Clause 49, questions to be determined. Clause 50, principles to be applied and appraising a change of control. Clause 51, media enterprises. Clause 52, appraisal of change in control. Clause 53, fees in respect of merger applications. Clause 54, time table for approval of changes in control. Clause 55, industry codes. Clause 56, codes adopted by the office.
The question is that clause 47 to 56 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 47 through 56 now stand part of the bill.
Clause 57, consumer codes of practice.
Honourable Minister, this is a proposed amendment.
Madam Chair, the way this is written, it is showing an amendment in 57 and 63B. Should I read them singly and just do 57 now? Thank you. I just wanted to make sure. Madam Chair, I move that in clause 57, we delete the words service providers and substitute the words sectoral providers.
The amendment has been duly moved. If there is no debate, I put the question that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendments stand part of the clause. I now put the question that the clause 57 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 57 as amended now stand part of the bill.
Clause 58, remedies.
I put the question that clause 58 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. Ayes have it. Clause 58 now stand part of the bill.
Clause 59, handling appeals from customers.
There's a proposed amendment to clause 59, Minister.
Yes, Madam Chair, thank you. In clause 59, we seek the amendment to delete the words service providers and service provider and substitute the words sectoral providers and sectoral provider, respectively.
Amendment has been duly moved. If no one wishes to speak, the question is that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 59 as amended stand part of the clause. The question now is that clause 59 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 59 as amended stand part of the bill.
Clause 60, consumer councils. Clause 61, alternative dispute resolution schemes. Clause 62, duty to promote innovation.
The question is that clause 60 through clause 62 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. Ayes have it. Clauses 60 to 62 now stand part of the bill.
Clause 63, duty to promote and facilitate universal service.
There's a proposed amendment to 63B, Minister.
Yes, Madam Chair, as we sought in clause 57, we so do in clause 63B to delete the words service providers and substitute the words sectoral providers.
Amendment has been moved. If no member wishes to speak, I put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye. Aye.
Against, no. The ayes have it. Clause 63 as amended stand part of the clause. The question now is that clause 63 as amended stand part of the bill. All those in favor, please say aye.
Aye. Aye.
Against, no. The ayes have it. Clause 63 as amended stand part of the bill.
Clause 64, strategic vision.
Put a question that clause 64 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. Ayes have it. Clause 64 now stand part of the bill.
Clause 65, interpretation for the purposes of this part.
Honourable Minister, there's an amendment to 65.
Madam Chair, we would propose in clause 65, 1 subsections A, B, and C, that the word utility be deleted and the word covered be substituted.
Amendment has been moved. If no one wishes to speak, I put the question that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stands part of the clause, and I put the question that the clause as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. Ayes have it. The clause as amended stand part of the bill.
Clause 66, agreements, etc., preventing, restricting, and distorting competition.
There's an amendment proposed for 66, Minister.
Madam Chair, in clause 66, in subclause 1, we move that the word licensees, wherever it appears, be deleted, and the words sectoral providers be substituted in each case. And in subclause 5, we move that the word licensee be deleted, and we substitute that for the words sectoral provider.
The amendment has been duly moved. If no one wishes to speak, question is that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stands part of the clause. Question now is that clause 66 as amended stand part of the bill. All those in favor say aye.
Aye. Aye.
Against, no. Ayes have it. Clause 66 as amended stand part of the bill.
Clause 67, individual exemptions. Clause 68, exemptions. Clause 69, cancellation, etc., of individual
The question,
exemptions.
the question is that clause 67 through 69 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. Ayes have it. Clause 67 and 69 stand part of the bill.
Clause 70, abuse of dominant position.
There's a proposed amendment to clause 70.
Yes, Madam Chair, continuing the massage. In clause 70,
I could find a different adjective, but continue.
I'm so sorry.
I could think of a different adjective, but continue.
I meant nothing by exactly but what it means, Madam Chair. In clause 70, in subclause 1, Madam Chair, we ask that the word licensees be deleted and be substituted by the words sectoral providers, and that the following words, that has been issued with a license pursuant to the Electricity Regulatory Authority Law 2010 revision be deleted. In subclause 2C, we seek to insert after the word disadvantage the words unless otherwise approved or exempted by the office. And Madam Chair, in subclause 3, we seek to have the word licensee deleted and that be substituted for the words sectoral provider.
The amendment has been duly moved. If no member wishes to speak, I put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stands part of the clause. The question now is that the clause 70 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 70 as amended now stand part of the bill.
Clause 71, officers' power to investigate. Clause 72, powers when conducting an investigation. Clause 73, power to enter premises under a warrant. Clause 74, entry of premises under warrant, supplementary. Clause 75, decisions following an investigation. Clause 76, directions in relation to agreements. Clause 77, directions in relation to conduct.
Question is that clauses 71 to 78 stand part of the bill. All those in favor, please say aye.
78? Forgive me.
77.
77, I beg your
Sorry.
pardon.
Okay.
The question is that clauses 71 through 77 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. 71 through 77 now stand part of the bill.
Clause 78, enforcement of directions.
There's a proposed amendment to clause 78.
Yes, Madam Chair. In clause 78, subsection 1B, we seek to delete the word utility wherever it appears and substitute the word provider.
The amendment has been moved. If no one wishes to speak, I put the question that amendments stand part of the clause. All in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendments stand part of the clause. The question now is that clause 78 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 78 as amended now stand part of the bill.
Clause 79, interim measures.
I put the question that clause 79 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 79 stand part of the bill.
Clause 80, penalties for infringement, and for infringing section 66 or 70, prohibition.
There's a proposed amendment to clause 8, Honorable Minister.
Thank you, Madam Chair. Madam Chair, we would ask that in clause 80, subclauses 1, 2, 3, and 4, that the word licensee be deleted wherever it appears, and that we substitute for that word the words sectoral provider. In subclause 3B, we ask that the word licensee be deleted and be substituted by the word authorization. And then in subclause 7, we ask that that subclause be deleted and be substituted by the following subclause 7. A penalty fixed by the office under this section in respect of any single infraction of section 66 or 70 by a sectoral provider or undertaking shall not exceed $3 million.
The amendment has been duly moved. If no member wishes to speak, the question is that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment now stand part of the clause. The question now is that clause 80 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 8 as amended stand part of the bill.
Clause 81, recovery of penalties. Clause 82, appropriate level of a penalty. Clause 83, agreements notified to office. Clause 84, cease and desist orders. Clause 85, application for enforcement.
Question is that clauses 81 through 85 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 81 through 85 stand part of the bill.
Clause 86, powers of court.
There's a proposed amendment, Honorable Minister.
Madam Chair, in clause 86, we would ask that the words 500,000 be deleted. We would ask that the words 3 million be deleted, and we would ask that they would be substituted sequentially by the words 250,000 and 1 million, respectively.
The amendment has been duly moved. If no one wishes to speak, I'll put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 86 stands part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 86 as amended stands part of the bill.
Clause 87, directions for immediate discontinuation of activity. Clause 88, matters to be included in directions. Clause 89, compliance with directions. Clause 90, powers of court in respective directions.
Question is that clauses 87 to 90 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 87 to 90 stand part of the bill.
Clause 91, administrative fees, fines.
There's a proposed amendment to 91, Minister.
Thank you, Madam Chair. We would seek to move in clause 91, subclause 11, that the words 21 days be deleted and substituted by the words 28 days, and by inserting after the words under subsection 10 the following words, open quotes, and an appeal may be made on one or more of the following grounds: A, erroneous in law; B, unreasonable; C, contrary to the principles of natural justice; or D, not proportionate. And in subclause 12, we would seek to delete the words 21 days wherever they appear and substitute the words 28 days.
Amendment has been moved. If no one wishes to speak, I'll put the question that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 91 as amended stand part of the clause. The question now is that clause 91 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. Ayes have it. Clause 91 as amended now stand part of the bill.
Clause 92, review of office determinations. Clause 93, powers of summary court. Clause 94, failure to obtain required authorization. Clause 95, failure to comply with the direction of the office. Clause 96, failure to pay penalty for contravention of information required of office required information. Clause 96, failure to pay penalty for contravention of information requirement. Clause 97, failure to comply with statutory duties or regulations. Clause 98, failure to comply with administrative determinations. Clause 99, obstruction of the office. Clause 100, unauthorized disclosure of confidential information. Clause 101, liability where offense committed by corporation. Clause 102, liability where offense committed by unincorporated entity. Clause 103, repeat offenses. Clause 104, initial funding. Clause 105, appointment of first board and first chief executive officer. Clause 106, conflict of interest.
The question is that clauses 92 through 106 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 92 to 106 now stand part of the bill.
Clause 107, confidentiality.
There's a proposed amendment to clause 107. Honorable Minister.
Yes, Madam Chair, we seek to amend clause 107 by inserting after subclause 9 the following subclause 10. Nothing in this law or the regulations shall require a person to produce or disclose a communication, A, which is one between a professional legal advisor and the professional legal advisor's client, or two, made in connection with or in contemplation of legal proceedings and for the purposes of those proceedings, and B, which in proceedings in a court would be protected from disclosure on grounds of legal professional privilege.
The amendment has been duly moved. The member from Easton wishes to speak.
Thank you, Madam Chair. Madam Chair, what's a professional legal advisor? A
Yeah.
what?
You're asking the minister or the attorney general, member? Honorable Minister.
Madam Chair, I am pretty confident that a professional legal advisor would be an attorney at law who's representing somebody or some entity.
Member from Easton.
Thank you, Madam Chair. I guess that's the new name for lawyers. I wonder if Madam Chair, I don't know, and somebody could explain. I mean, the Attorney General could, or the Premier could, or one of the many lawyers. I don't want to pressure my good friend. Pardon me? It doesn't include me, thank God, because I would have been alongside you. Madam Chair, I'm wondering if why that would have to go in here. Isn't that a given that privileges, legal attorney-client privileges is a given? I'm wondering, because we have heard that said many times in the last few weeks.
Before he answers, Madam Chair,
Honorable Leader of the Opposition.
does the word professional, what does it say? I mean, the lawyer is a professional. I think it's repugnant to the bill, using that to describe a lawyer.
Honorable Minister, I think you have two questions. One wants the definition of legal professional privilege, and one wants a definition of professional. So you perhaps could make one answer.
Madam Chair, I would answer in my lay terms, but let me consult to see if I should answer differently. If you don't mind, give me 2 seconds. Madam Chair, I think I can answer this, but I am more content if my professional legal advisor would respond to it, Madam Chair.
I did ask your professional legal advisor, but he was being very courteous. Honorable Attorney General, to be absolutely constitutional, can you please respond?
Thank you, Madam Chair. Madam Chair, no, the observation is correct. Professional legal advisor is another way of saying an attorney. It says that attorney-client privilege that is protected. Yeah. And the second one, why is inserted in there? It is true, Madam Speaker, that at common law it is presumed, but it is always advisable, if necessary, to put it in the legislation so that it is expressly provided there, rather than having to argue whether or not it applies.
Madam Chairman,
Honorable Leader of the Opposition, followed by the member from Easton.
Madam Chair, I wouldn't never hold an argument with the learned Attorney General, but can he tell me where, what other legislation this has been used in Cayman?
I think we have it in the proceeds of crime law. We have it in the what's the one?
Yeah.
We have it in a couple of pieces of legislation. We started out, I think, if I can remember, in the proceeds of criminal conduct law, and then we imported into the proceeds of crime law, and there are a couple of other pieces of legislation that we do have it in.
Recent times.
Yeah.
Member from Easton, you still have a question?
Yes. Well, Madam Chair, I wonder if the Attorney General, since he is speaking, can tell us how that relates to the legal practitioners bill. Would that now be called legal professional advisor practitioners bill? And
really late.
and how come, if that is to govern, the LPB is to govern attorneys, because it's represented in there as attorneys, what's the relationship between them? Is there any possibility of that being a little broader than just an attorney and it's a legal professional? That's what I'm asking.
Legal professional privilege applies to, it's attorney-client privilege. That's what we're talking about. So it's privileged communication between an attorney and his client.
But isn't that, Madam Chair, I'm just wondering, isn't that a known fact? Isn't that in common law? Or, yeah.
Doesn't hurt.
Is it not that obvious that it has to be placed in here that the lawyer can't, or the client don't have to disclose it?
No, well, no, I understand what you're saying, member, but usually what would happen, if there is an issue arising under the law, you would probably spend half a day to argue about whether or not legal professional privilege applies.
Oh.
Whereas all you really need to do is turn to the section, and it's expressly stated there that it does apply. So the thing is covered by attorney-client privilege.
Okay, and I appreciate that, but should that not be in all the laws then? Okay.
Are there no further debate? I put the question that amendments stand part of the clause. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. The amendments stand part of the clause. The question now is that clause 107 as amended stand part of the bill. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. Clause 107 as amended now stand part of the bill.
Clause 108, unauthorized disclosure of confidential information. Clause 109, immunity. Clause 110, indemnity. Clause 111, regulations. Clause 112, amendment of schedules.
I put the question that clauses 108 through 112 stand part of the bill. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 108 through 112 now stand part of the bill.
New clause 113, transitional provisions.
Honourable Minister.
Thank you. Madam Chair, we would seek to insert after clause 112 the following clause. In the marginal notes, we'll read transitional provisions. 113, which will read, where immediately prior to the date of commencement of this section, a licensee held a license which contained a waiver similar to that which is contained in Section 46, subsection 5, the waiver shall be deemed to be a waiver granted by the office under Section 46, subsection 5, and shall continue in force subject to the conditions contained in the original waiver. And U, in Schedule 1, by deleting the following words: production, distribution, and supply of potable water and non-potable water as a utility service, provision of wastewater services as a utility service. And Madam Chair, that quickly is to explain that it is because this will be in the pending legislation to come in January. Madam Chair, just before you take the vote, if you don't mind, I would like to say a sincere thank you to my colleagues here who have been long suffering, because I know the committee stage amendments were tedious. But again, want to say thanks to them. There were some who spoke on the bill, including the member from East End, the fifth elected member from Georgetown. And certainly some of these amendments emanate from points that they made. And added to that, Madam Chair, I would just like to thank Ms. Myrtle and the Attorney General's office, the drafting team, for their very hard work in getting it this far so that we can have this much of it for this meeting. Thank you.
If there's no debate, the member from East End.
Madam Chair, I mean, in the minister's presentation of these two sections here, he said that it's coming in the next set of legislation. Why can't we leave it in here?
Because we have each of them. Madam Chair, we have each of the various laws separately for each sector. And then this was the overarching bill. There were concerns from stakeholders, including the water company, that this was in this piece of legislation and nothing accompanied it. And that's really all it was just to make sure nobody was nervous regarding that they might have thought we were trying to do this and not do anything else and just leave it like that.
Okay, so it won't be then that it don't go back in as well.
Right, whatever has to tie the overarching legislation with all of them will be done in accord with that when we bring back the rest of the stuff for the water production law, the water authority law, and the sewage one.
Okay.
If there's no further debate, the question is that the new clause be inserted into the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The question is now that a new clause 113 and the amendment to schedule be inserted to the bill and stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. New clause 13 has been inserted, an amendment to the schedule to the bill.
Madam Chair, just for
Honorable Attorney General.
completeness, the leader of the opposition, for example, asked whether we ever use the expression legal professional privilege in any other law. We have it, for example, in the Freedom of Information Law, page 15 of the law. So, freedom of information. Thank you.
Schedule 1, marketed and sectors for which the office has responsibility. Take a vote on that. No.
Schedule 1. The question is that Schedule 1 be part of the bill. All those in favor, please say aye.
Oh,
Aye.
sorry, there is an amendment.
Oh, there's an amendment to that as well, Minister.
Madam Chair, I made a mistake and read that already when I should not have. So why are we doing it again? Oh, I see. But we really don't, or do we? If it's to make sure it happens, I will do so. I'm guided by you, Madam Chair.
We did it, sir.
Okay.
Scheduled,
And you're just making sure everybody understands. Thank you.
Schedule 2, sectoral legislation.
The question is that Schedule 2 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Schedule 2 now stand part of the bill.
A bill for a law to establish a multi-sector regulatory body, corporate, to be known as the Utility Regulations and Competition Office, to set out the office, broad functions and powers, and the administrative arrangements for its governance and operation, and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
That's all right.
Honorable Member.
Yes,
Opposition.
Madam Chair. We just passed this bill, I think. How many, can the minister say how many amendments? Because it seems to me like 5 pages of amendments. How many amendments?
Madam Chair, I wish not to be rude, but I've not counted them. If you would want me to count them, I could.
I wouldn't wish you to be rude, but
I'm not being rude.
But I would tell you that
I've never counted.
What I am worried about is that we here on a weekend doing this many 5 pages to one bill, and as well as an important bill, it is still 5 pages. It's a lot to consume. I see the next one coming is education. I don't know how much that got. That must be half of that bill must be amended.
I think this one was 24, Madam Chair.
The Criminal Records Spent Convictions Bill 2016, Clause 1, short titling commencement.
Aye.
All those in favor, please say aye. Against, no. The ayes have it. Clause 1 stand part of the bill.
Clause 2, interpretation.
Honourable Member from Northside, Clause 2. Of the Criminal Records Spent Convention Bill 2016. We had deferred it early on.
Madam Chair, I think I had moved that and was being debated, and then the Premier said that we had to stop because, so you want me to move it again? Because
have you received the amendments have been circulated? That's why
Yes.
we actually took the break. But yeah, it probably would be beneficial to move it again because I think members probably don't even remember the title, much less what you moved about a couple hours ago.
I'm beginning to feel like the leader of the opposition here. Like, you got so many amendments, you don't know where you're going. Madam Speaker, in what I had asked to be done in clause 2 was under the definition of conviction to delete B, which says a conviction by or before a court outside the islands, be deleted.
Madam Speaker,
Honorable Premier.
we've been through that extensively, and I've explained why the government believes that it's important that the definition stay as it is. I don't need to repeat that again.
If there's member from Northside you wish to reply, or there's
No, Madam Speaker, put it to the vote now.
if there's no further debate, the question is that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those against? I believe the ayes have it.
I haven't said, we haven't called it no vote yet, ma.
Just said no. Nobody said anything. It passed, and we can't get rid of that one.
No, never asked for no. I know it's late.
Oh, yeah, it's too late. You all can't keep doing
The
it.
question is that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no.
No.
Madam Speaker,
I said aye and I didn't put no, Mr. Bush. That's why I'm doing it over.
Madam Speaker, I would have to check that back to make sure that we never just voted twice. No, did you not? Did she
Madam
not say
Clerk,
no?
please call a division. Alden asked.
And we wake up and keep us up in this late hour now, just sleeping and snoring and doozing.
Yeah.
Should we? It's what I will mean, Para.
Madam Speaker,
Get on with you.
this is getting ridiculous now, but can I ask for a division so that we can be sure?
Madam Clerk.
McKeever was going to pick up your thing and go home,
Yeah, but I fix it correctly.
Honorable Alden McLaughlin.
No.
Honorable Moses Kirkconnell.
No.
Honorable Kurt Tibbetts.
No.
Honorable Oswald Bodden.
No.
Honorable Wayne Panton.
No.
Honorable Marco Archer.
No.
Honorable Tara Rivers.
No.
Honorable Mr. Roy McTaggart.
No.
Mr. Joseph Hugh. Honorable McKeever Bush.
Madam Speaker, Mr. Chairman, what are we voting on?
We're voting on
I'm sorry, but I mean, we just.
Mr. Honorable Leader of the Opposition and other members, we're voting on the amendment that was moved by the member from Northside as it relates to Clause 2 of the Criminal Records Spent Convention Bill 2016.
Oh yes, yeah. Vote for that. Aye.
Mr. Barney Bush. Kempton Eugene Ebanks.
Aye.
Mr. Albert Saku.
Aye.
Mr. Winston Conley.
Aye.
Mr. Ezra Miller.
Aye.
Mr. Arden McLean.
Aye.
Honorable Anthony Eden.
Sounds like aye.
1, 2, 3.
The next one is to do.
The results of the division are as follows: 7 ayes, 9 noes, 1 absentee. The proposed amendment has not been carried.
Madam Chair,
Honorable Premier.
in accordance with the provisions of Standing Order 52, 1 and 2, I give notice to move the following amendments to the Criminal Records Spent Convictions Bill 2016. That the bill be amended as follows. A, in clause 2, as follows. In the definition of the word firearm, by inserting after the word firearms the word law, and in subclause 3B, by deleting the words is to and substituting the word shall.
The amendment has been duly moved. Honorable Leader of the Opposition.
Just going to ask the minister to explain it.
Honorable Premier.
Because I don't think he would. I don't think
Madam Chair, the difficulty with this is cleaning up drafting errors. If you go to page 12 of the bill, in the definition section, which is clause 2, you will see that there is a definition of firearm, but it says has the same meaning as in section 2 of the Firearms 2008 revision. It should say firearms instead of the singular, and it should say firearms law instead of just Firearms 2008 revision. So these changes are just to clean up that from a drafting standpoint. And in subclause 3B, Madam Chair, I'm just seeing if the Honorable Leader of the Opposition is following me. Right. So in subclause 3B, on page 13, at the bottom of the page, it currently reads, for the purposes of this law, no account is to be taken of any subsequent variation of a term originally imposed by a court. And the proposed amendment is to delete the words is to, so that it reads no account be taken of any subsequent variation of a term. Sorry, no account shall be taken instead of no account is to be taken. Nothing substantive, in other words.
If there is no further debate, I'll put the question that the, oh, sorry, member from Easton. Clause 2, the government's amendment. You okay? The question is that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendments stand part of the clause. The question now is that clause 2, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 2, as amended, now stand part of the bill.
Clause 3, law binds the Crown.
Put the question at clause 3, stand part of the bill. All those in favor, please say aye.
Aye.
3. You had a question, sir?
Is this coming on to clause 3F on page 2?
Yeah, Once it's under clause 3, you can ask a question.
Yes, that's the, where it says by inserting after clause 29 the following clause. Can the mover, the minister, explain what this is all about?
Honourable
Sorry,
Premier.
Madam Chair, I'm not sure what I'm being asked to explain.
Honourable Leader of the Opposition, could you kindly repeat?
Yes, and if you're doing clause 3, and then you,
Clause 3 simply says the law
That's-
binds the crown.
yes, that's what was asking on page 2, where it says C or E, and then you come down to F. No, you're not got to that yet. You haven't got to that yet. Okay.
I put the question that clause 3 stands part of the bill. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. Clause 3 stands part of the bill.
Clause 4, object of this law.
Honourable Premier, you have an amendment proposed
Yes,
for
Madam
clause
Chair.
4.
In accordance with the provision of Standing Order 52(1) and 2, I beg to move that the bill be amended in clause 4 by deleting the words is to and substituting the word shall.
The amendment has been moved. Does any member wish to speak to the amendment? If no, I'll put the question. Member from Easton. The question is that amendments stand part of the clause. All those in favour, please say aye.
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 Against, no. The ayes have it. The amendment stands part of the clause. The question is now that clause 4 as amended stand part of the bill. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. Clause 4 as amended stand part of the bill.
Clause 5, expungement board established. Clause 6, functions of the board. Clause 7, finding and orders considered to be convictions.
I put the question that clauses 5, 6, and 7 stand part of the bill. All those in favour, please say aye.
Aye.
Against, no. Ayes have it. Clauses 5, 6, and 7 now stand part of the bill.
Clause 8, convictions imposed in other countries.
Member from Northside, proposed amendment.
Thank you, Madam Chair. Yeah, man, I filed an amendment to delete A1 and A2, which is consistent with having the definition changed earlier.
The amendment has been duly moved. Does any member wish to speak? Honourable Premier.
Madam Chairman, for completeness and for the sake of the record, this section and these two subsections in particular provide that the law shall apply to a conviction for an offence against laws other than the laws of the Cayman Islands. And for the reasons which I have previously explained, it is critically important to the effectiveness of this bill that this law operates on the basis of reciprocity, and that in order to obtain that reciprocity for Cayman, we have to have provisions like this in our law that we will recognize convictions and offenses against other laws other than the laws of the Cayman Islands, if we want those other countries to do likewise with respect to us.
Member from Northside, do you wish to reply?
Verse 8, this is
The question is that amendment stands part of the clause, that is Amendment 8. All those in favour, please say aye.
Aye.
Those against, no.
No.
I believe the noes have it. Accordingly, the amendment has not been carried. The question is that Clause 8 stand part of the bill. All those in favour, please say aye.
Aye.
Those against, no. I believe the ayes have it. Clause 8 now stand part of the bill.
Clause 9, convictions of prohibited immigrants.
Madam Chair, in accordance with the provisions of Standing Order 52(1) and 2, I give notice to move the following amendment to the Criminal Record Spent Convictions Bill 2016. That the bill be amended in Clause 9 by deleting subclause 2, which reads as follows: where a person's criminal record has been expunged in circumstances described in subsection 1, that person may re-enter the islands to live or visit after satisfying the requirements of such law as may for the time being be enforced in relation to prohibited immigrants. For that to be deleted and for the following subclause to be substituted: where a person's criminal record has been expunged in circumstances described in subsection 1, that person may, subject to the provisions of the Immigration Law 2015 revision, re-enter the islands to live or visit.
The amendment has been moved. As a member wishes to speak to the amendment, member from Easton.
Madam Chair, the deputy governor said that, as I recall, that the fact that the record has been expunged does not mean that they're not subject to the requirements
For cabinet to bring them in.
based on prohibited immigrants. That's what he stood up there and said, that application would still have to be made.
Yeah.
But that also goes for Section 10.
Yeah.
But
Yeah. It's still subject to the provisions of the immigration law.
that, yeah, but under the, Madam Chair, if you bear with me, under the original proposal, it said subject to, as may for the time, subject to the requirements of, by satisfying a visit, after satisfying the requirements of such law as may for the time being be enforced in relation to prohibited immigrants, which is an application to cabinet. And then the other one was 10 was to be for the time being enforced in relation to deportees. That's under 10. And the deputy governor, in his winding up, said that that meant they were still subject to applying to cabinet after it has been expunged to re-enter the country. Now this removes it.
No, Madam Speaker.
Honorable Premier.
No, Madam Speaker. The change that has been made here was actually a change made as a result of representations made by someone on that side. I can't remember precisely who. And it wasn't the deputy governor who was winding up on this bill. This was the bill I presented, so I wound up on the bill.
Oh, no.
Yes. Yes, Madam Speaker. I wound up on the bill. The deputy governor made a contribution.
Okay.
Yeah.
Okay. All right, I'll take your word for it.
If the record's bared out.
Madam Speaker, there were concerns expressed by someone on that side that we weren't specific about the law. And so this change, the change in Clause 9 and the change in Clause 10 simply removes the expression of such law and specifies the immigration law, because it's in the immigration law that the provision relating to prohibited immigrants resides.
Application to cabinet.
Yeah, but there are specific sections in there relating to prohibited immigrant, either two, and deportees.
What's the point?
The point is that the deputy governor said that the fact that the record has been expunged does not mean they can just re-enter. It will still require an application made to the cabinet.
Madam Chair, that's precisely what the section, the clause that are saying, that the person may, subject to the provisions of the immigration law.
Yeah, but not as a prohibited immigrant.
Generally, doesn't matter how, they are still subject to the provisions of the immigration law. So if they have been deported, if they have been declared a prohibited immigrant, they have to go through the required processes under the immigration law to be able to re-enter.
So why are we taking it out then, the specific provision?
Madam Chair, we've taken nothing out.
We are.
No, Madam Chair, all the new clause does is to substitute the immigration law for such law. That's all it does. Makes no other change.
No. I mean, you mean tell me my eye is that bad, Madam Speaker? Are we on 9? Okay. Maybe it is me, but I guess I can read it and see if I miss the boat altogether. 9 currently says, in mine, because we know how that is nowadays.
9(2).
9(2) says, where a person's criminal record has been expunged in circumstances described in subsection 1, that person may re-enter the islands to live or visit after satisfying the requirements of such law as may for the time being be enforced in relation to prohibited immigrants. We are substituting with where a person's criminal record has been expunged in circumstances described in the subsection 1, that person may, subject to the provision of the immigration law 2015 revision, re-enter the islands to live or visit, subject to the immigration law, apply for a work permit. That's how you enter this country.
Madam Chair, as I said, this change was made based on the representations from that side. The law that governs prohibited immigrants, convicted and deportable people, destitute people,
Right?
all of is the immigration law. Specifically, it is section 89(1). So what this law is doing is importing the provisions of the immigration law and saying quite clearly that where a person's criminal record has been expunged in the circumstances described in subsection 1, that person may, subject to these provisions, re-enter the islands to live and visit. So if the person has been made a prohibited immigrant, they will not be allowed in unless they have been subsequently granted permission in the way that it operates now through cabinet to come back, because the provisions of the law are what obtain.
I don't know which law he is looking at.
The
Which
immigration law 2015 revision.
I'm looking at the same one, but you're saying it's 8 and 9, but about prohibited immigrants, and this one says 82. Again, this one gone bad now too.
It's 89(1).
I thought that was deportees, the people deported.
89(3) deals with deportation orders.
8 and 9 says power of governor to make, revoke, vary, or modify a deportation order and duty to report to Secretary of State. 82 says prohibited immigrants. No, maybe, Madam Speaker, can we get another law because this one wrong?
But Madam Chair, that is neither here nor there or there. The important point is that no one, just because a record has been expunged, does not simply clear the way for people to come without having regard to the relevant provisions, whatever they are, depending on their particular circumstances, without regard to the immigration law. That's the important point. The precise sections don't really matter.
Through
Member
Madam
from
Chair,
Northside.
would the Premier consider putting back after satisfying the requirements of the immigration law, as opposed to just say subject to the provisions of the immigration law?
It's the same thing.
All right, okay.
Subject to.
Or specify the section of the immigration law so that nobody can say
Right.
it's another section of the law that they're coming under.
No, the difficulty with specifying a specific section is if there is some reason why other sections apply. This way, we've imported the entire law. So whatever section applies, applies.
Madam
Member from
Chair,
Easton.
I know we're not going to get this out of here. I hate to see it in here, which I've said before. But in the interest of getting the best possible thing, because we know that one person out of immigration is going to interpret it one day, next one going to interpret, and by time you get down the end of the corridor, 5 people have interpreted it different. It's either on a temporary work permit, or on a full work permit, or on a visitor's permit, and now the thing will be heard about prohibited immigrant permit.
Madam Chair, there is a
Honorable Premier.
there is a stop list which immigration has, and there's are specific procedures that have to be gone through to have a name removed from the stop list. So if they're on the stop list, then if they come, they'll be stopped, it'll be flagged, and then whatever action taken will be taken. It's not simply a matter for an immigration officer to decide that they can take somebody off the stop list. It doesn't work that way.
If there's no further debate, the question is that amendment stands part of the clause. That is the government amendment. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 9 as amended stand part of the clause. The question now is that clause 9 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. I believe the ayes have it. Clause 9 as amended now stand part of the bill. Honourable member from Northside, I believe you had an amendment to clause 9.
But if my amendment was to delete the clause, so I'm not going to waste the time at the house because then I got. I withdraw the amendment.
Okay. The question is that clause 9, as proposed by the member from Northside, that the committee supports the withdrawal. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. Clause 9, as presented from the member of Northside, has been withdrawn.
And Madam Chair, you can do the next one for clause 10 as well.
The question is that clause,
That my amendment is withdrawn. Because they're not.
Clause 10, convictions on deportees.
the question is, as clause 10 amendment as proposed by the member from Northside be withdrawn. Those in favour, please say aye.
Aye.
Against, no. The ayes have it. Clause 10 amendment as presented by the Northside member has been withdrawn. Honourable Premier, I think you had an amendment to clause 10 as well.
Yes, Madam Chair, in accordance with the provisions of Standing Order 52, 1 and 2, I move that the bill be amended in clause 10 by deleting subclause 2 and substituting the following subclause. Where a person's criminal record has been expunged in the circumstances described in subsection 1, that person may, subject to the provisions of the Immigration Law 2015 revision, re-enter the islands to live or visit.
The amendment has been moved. Does any member wish to speak to the amendment? If no, I put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stand part of the clause. The question now is that clause 10 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 10 as amended stand part of the bill.
Clause 11, convictions before the commencement of this law. Clause 12, convictions that cannot be expunged. Clause 13, pending charges.
The question is that clauses 11, 12, and 13 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes barely have it. Clauses 11, 12, and 13 now stand part of the bill.
Clause 14, minor offenses relating to marijuana.
A member from Northside has an amendment, clause 14.
Thank you, Madam Chair. Yeah, Madam Chair, I filed an amendment to clause 14 to try to attach the conditions of 14.2 to 14.1 and also to make it automatic and not subject to a board's approval. And the amendment to clause 14.1 would be to, after a similar offense under a law where the sentence is non-custodial and if a fine is imposed where the fine did not exceed $5,000, that person's criminal record shall be expunged upon the coming into the force of the law.
The amendment has been moved. Does any member wish to speak to it?
Madam
Honorable
Speaker,
Premier.
Madam Speaker, we've addressed this comprehensively in the debate on the bill, and we've explained that the reason why there isn't automatic expungement is that it was felt by us that we cannot trivialize these offenses to a point where people can go and commit the offense, and the minute they pay the fine, the offense disappears. It doesn't even get put on the record. That they should have at least to make an application to the expungement board and go and make their case. Because until the day that possession and consumption of marijuana is legal in these islands, if it is a criminal offense, it is a criminal offense, and it cannot simply be treated as though it's just an occurrence. So that is the reason why we have drafted the bill the way we have, and that's the reason why we are unable to accept the amendment. I understand the intent behind it, but it will truly trivialize the offense, we believe.
Madam Speaker,
Member from Northside.
that's not entirely so in what I've asked here, because the people who, some of these persons will have had this record for years when the law comes into effect. On the second section, which I am asking for, that it be done automatically after the law comes into effect, it would only be 6 months after the offense was committed, is added today. The record would remain on until 6 months, and then it would be expunged in the section 2.
Honorable Premier.
Madam Speaker, as we've explained, we believe that they should have to make the application to the expungement board.
The problem I have, Madam Speaker, with this whole expungement board is that the people in town who have money go get their children's the young people record cleaned up. The people, like in my constituency, who don't have access to justice other than getting arrested and going to jail or getting fined, ain't gonna have much opportunity to come to this expungement board to get their record cleaned up.
Honorable Premier.
Madam Speaker, I don't buy that at all. All it will cost is whatever it costs to get from Northside to Georgetown to make the application. This is not a complicated process that requires a lawyer.
If there's no further debate, I put the question that the amendment stand part of the clause, that is the clause 14 amendment as proposed, the member from North Side. All those in favor, please say aye.
Aye.
Those against, no. No. I believe the noes have it. The amendment therefore is not carried. I put the question that clause 14 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 14 now stand part of the bill.
Clause 15, application for expungement.
I put the question that clause 15 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 15 now stand part of the bill.
Clause 16, inquiries by board.
Member from North Side.
Thank you, Madam Speaker. Madam Speaker, I've asked for amendment to clause 16 to delete 1C and clause 2 because I don't understand why we worried about the expungement board embarrassing or bringing the administration of justice into disrepute. Why we need that?
Honorable Premier.
Madam Speaker, Madam Chair. Of course, the board would want to consider the circumstances of each case and to determine whether or not it is appropriate for the record to be expunged. Not all circumstances in every case are exactly the same, and there may be powerful reasons why, notwithstanding the lapse of time, that based on information which the expungement board has, they would deem it an affront to the administration of justice to expunge the record. We don't know what all those circumstances are. What this provision is intended to do is to invest the board with the discretion and the competence to make those determinations. We can't get to a point in our effort, and all of us, I believe, share this, wanting to help people who have really turned their lives around and cleaned up their act, to use an overused expression. While we want to help them, we can't get to a point where there is no consequence which flows from people committing crimes. And we need, this power, this new power has to be exercised very judiciously, very carefully. And so we have to ensure we have the right people on the board, but we also can't tie their hands. We have to be able to give them the discretion to make judgments about who should get their record expunged and who should not, based on the circumstances of their particular case.
So
Member from North Side.
So, Madam Chair, the crime-free period that is specified in Schedule 3, for example, under 3, a sentence of imprisonment for a term exceeding 3 years, but not exceeding 5 years. Even if the person remained crime-free for that 10 years, the expungement board could refuse to expunge their order because they believe it would look bad on the justice system.
There may be information which there may be information which comes to the board about the activities of the individual, even though they have not yet been subsequently convicted. For instance, the person could have just been arrested again for a serious offense, but not convicted, or have a pending court case, as an example.
Granted.
Member from North Side.
Granted, Madam Chair, and I would accept that could be, but my concern is that, because none of that is specified in here, the person was arrested or had a pending court case. It's just saying that the board has the discretion not to grant.
But
okay.
I just wish that the minister had the my comment, because that's exactly what I was going to say. We can't sit and contemplate every possible circumstance which might cause the board to have doubts about whether or not they should expunge the record. So you've got to trust the people that you put there, and you've got to give them the discretion to be able to make good judgments, just as we do with our judges.
The question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no.
No.
I believe the noes have it. Therefore, the amendment is not carried. I put the question that clause 16 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 16 stands part of the bill.
Clause 17, presentation. Clause 18,
What was-
computing date of expiration of sentence. Clause 19, reapplying.
I put a question that clauses 17 through 19 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 17 to 18 stand part of the bill.
Clause 20, spent convictions.
Honorable Premier, you have an amendment to 20.
Thank you, Madam Chair. Madam Chair, pursuant to Standing Orders 52.1 and 2, I move that the bill be amended in Clause 20 as follows. In subclause 1, by deleting the word is and substituting the words shall be. And in subclause 3, by deleting the words is not to and substituting the words shall not.
If there is no debate, I'll put the question that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. I believe the ayes have it. The amendments stand part of the clause. And I'll put the question that clause 20, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 20, as amended, stand part of the bill.
Clause 21, crime-free period for convictions of court other than juvenile court. Clause 22, crime-free period for orders of a juvenile court. Clause 23, convictions in relation to traffic offenses. Clause 24, application, crime-free period. Clause 24, applicable, crime-free period. Clause 25, crime-free period in relation to multiple sentences. Clause 26, effect of expungement of criminal record in general. Clause 27, effect of expungement of judicial proceedings. Clause 28, effect of expungement of non-judicial proceedings.
The question is that clauses 21 through 28 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 21 through 28 now stand part of the bill.
Clause 29, effect of expungement on laws, agreements, and arrangements.
Honorable Premier, propose amendment to 29.
Madam Chair, pursuant to Standing Order 52.1 and 2, I move that the bill be amended in Clause 29 by inserting after Clause 29 the following clause. For the avoidance of doubt, the provisions of this part shall not operate to prevent a person from being disqualified to be elected as a member of the Legislative Assembly pursuant to Section 62(1)(e) of Schedule 2 of the Cayman Islands Constitution Order 2009.
Madam Chair,
The amendment has been moved. Is there any debate? Honorable Leader of the Opposition.
just to ask the Premier to make clear what that provision means.
Honorable Premier.
Madam Chair, under the provisions of Section 62(1)(e), Schedule 2 of the Cayman Islands Constitution, Order 2009, there are a list of things, for lack of a better word, which disqualify an individual from standing for election. One of those is, and that is 62(1)(e), subject to subsection 2. But no, let me start. No person shall be qualified to be elected as a member of the Legislative Assembly who, subject to subsection 2, is serving or has served a sentence of imprisonment by whatever name called, exceeding 12 months imposed on him or her by a court in any country, or substituted by a competent authority for some other sentence imposed on him or her by such court, or is under a sentence of imprisonment, the execution of which has been suspended, or has been convicted by any court in any country of an offense involving dishonesty. So what this proposed provision to be added as 29A does is to make it quite clear that expungement does not have the effect of attempting to override a constitutional provision. It is doubtful it could ever do that in any event. But notwithstanding the expungement, that would not result in removing this disqualifying circumstance.
If the record is...
Honorable Leader of the Opposition.
Thank you. If the record is expunged for matters under 12 that you're proposing of the bill,
12.
Clause 12.
12. What was 12?
12 convictions that cannot be expunged.
Right.
If the record is expunged, the constitutional provision still applies.
With respect to standing for elections.
Yes. For the various things that this is saying. Can be. Yes. Against corporate bodies, detentions and all sorts of things is thrown in here. A conviction against a corporate body, a conviction resulting in a sentence of detention during the court's pleasure.
Order.
No, Madam Chair, it's the other way around.
The matters under Section 12 can't be expunged.
That's what I'm saying. They cannot be expunged.
Right.
Yes.
So, but the provision that the permit just read is to ensure that persons who are expunged
Otherwise, if the record is expunged, the constitutional provision
Still
cannot be expunged.
still prevail.
If there is no other debate, the question is that the amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendments stand part of the clause. Question is that Clause 29, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 29, as amended, stand part of the bill.
Clause 30, defamation actions. Clause 31, saving the royal prerogative.
The question is that clauses 30 and 31 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 30 and 31 now stand part of the bill.
Clause 32, circumstances where persons shall disclose expunged convictions.
Honorable Premier, there's a proposal for amendment. The 32.
Yes, sir.
Thank you, Madam Speaker. Madam Speaker, pursuant to Standing Order 52(1) and 2, I move that the bill be amended in Clause 32 as follows. In subclause 1, as follows, paragraph B, by deleting the word or. In paragraph C, by deleting the full stop and substituting the word or. And C, by inserting after paragraph C the following paragraph. D, be elected as a member of the Legislative Assembly. And in subclause 2, as follows. Paragraph B, Roman 2, by deleting the word or. In paragraph C, by deleting the full stop and substituting the word or. And C, by inserting after paragraph C the following paragraph. D, to the Supervisor of Elections.
The amendments have been moved. If there is no debate, I put a question that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stand part of the clause. The question now is that clause 32, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 32, as amended, now stand part of the bill.
Clause 33, failure to disclose expunge criminal records when disclosure required. Clause 34, unauthorized disclosure of expunged criminal record. Clause 35, keeping and protection of expunged criminal records. Clause 36, protection of disclosure of discharges. Clause 37, notional and verification of records. Clause 38, disclosure and use of information. Clause 39, revocation of expungement. Clause 40, representation. Clause 41, limitation on expungements. Clause 42, disclosure of decisions relating to expunged criminal records. Clause 43, reports to the Legislative Assembly. Clause 44, law does not authorize contravention of other laws. Clause 45, law does not affect certain other lawful acts. Clause 46, non-destruction of records. Clause 47, judicial review.
If there's no debate, I put the question at clause 33 to 47. Stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 33 through 47 stand part of the bill.
Clause 48, regulations.
Honorable Premier, this is an amendment to 48.
Thank you, Madam Chair. Madam Chair, pursuant to Standing Orders 52.1 and 2, I move that the bill be amended in clause 44G by deleting the words is to and substituting the word
44, is it?
48G. Sorry, ma'am, that's what my paper says. It should be 44, should it?
48G.
Oh, I'm sorry. I'm hearing 48. In clause 48G, by deleting the words is to and substituting the word shall.
The amendment has been moved. If no member wishes to speak, the question is that amendment stands part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 48. The amendment to clause 48 stand part of the clause. The question now is that clause 48 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 48 as amended stand part of the bill.
Clause 49, repeal of Rehabilitation of Offenders Law, 1998 revision.
I put the clause at clause 49 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. Ayes have it. Clause 49 now stand part of the bill.
Schedule 1, expungement board.
Member
Madam
from
Chair,
Northside.
Given the absolute distaste and other adjectives used by the Premier about the governor appointing boards, does he want to consider changing this one and have cabinet make the appointment. Because this is solely the board. You don't want to go backward any further than I try to take you.
Honorable Premier.
It's late, Madam Chair. I won't rise to debate.
Honorable Premier, you have an amendment to Schedule 1.
Yes, Madam Chair. Pursuant to Standing Order 52, 1 and 2, I move that the bill be amended in Schedule 1 as follows. In paragraph 4, by deleting the words is to and substituting the word shall. In paragraph 6, by deleting the words is to and substituting the word shall. In paragraph 10(1), by deleting the words is to and substituting the word shall. And in paragraph 14 as follows. In subparagraph 1, by inserting after the word was the words negligent or. And in subparagraph 2, by inserting after the words caused by the words negligence or, semicolon, and.
If there is no debate to Schedule 1 as the proposed amendment, I put the question that the amendment to the Schedule 1 stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment to the schedule stand part of the clause. The question now is Schedule 1 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Schedule 1 now stand part of the bill.
Schedule 2, offenses the record of which cannot be expunged.
I put the question that Schedule 2 stand part of the bill. Those in favor, please say aye.
Aye.
Against, no. The ayes have it. Schedule 2 now stand part of the bill.
Schedule 3, crime-free periods in relation to sentences.
Recognize the Honorable Premier.
Thank you, Madam Chair. Pursuant to Standing Order 52, 1 and 2, I move that the bill be amended in Schedule 3 in Item 5 by deleting the words 7 years and substituting the words 5 years.
The amendment has been moved. Does any member wish to speak?
Madam Chair, this is correcting the matter that was picked up by some members of the opposition when they were going through the schedule. Well, I'll give the member from Northside credit for it. It was a typographical error. I'm happy he picked it up, and we are fixing it.
The question is that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stand part of the clause.
Madam Chair, I therefore withdraw my amendment to clause Schedule 3.
The question is that the amendment filed to Schedule 3 by the Honourable Member from Northside be withdrawn. Those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment from the member from Northside is not carried.
Yeah, it's carried because the same one he did, mine was withdrawn. I'm withdrawn my.
I beg your pardon. The motion for the withdrawal from the member of Northside for his proposal has been withdrawn.
Yeah.
Thank you. I put the question that Schedule 3, as amended, stands part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Schedule 3, as amended, now stand part of the bill.
Schedule 4, persons who must disclose expunged criminal records.
The question is that the title stand part of the... Schedule 4. You can tell I read it go. I put the question that Schedule 4 stands part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Schedule 4 now stand part of the bill.
A bill for a law to repeal and replace the Rehabilitation of Offenders Law 1998 revision to establish a board for the purposes of expunging criminal records to enhance the rehabilitation process and for incidental and connected purposes.
The question is that the title now stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. I believe the ayes have it. The title now stand part of the bill. We have 2 remaining pieces for the committee stage. Is there an indication that we're going to complete these 2 premier, or are you going to give us a Friday evening adjournment?
Madam Chair, we were just having a quick discussion here. We would like to complete the elections, one, because we don't think that's going to be too much longer. But I would ask for an indication from the committee whether we want to persevere and do the education bill this I can't even say this evening or tonight, but I expect that's going to be a couple of hours more. Or whether we want to defer that until Monday, because I have had to concede that Monday is inevitable because we have a stack of motions as well. So there's just no way we're going to get through the whole of it this evening anyhow.
Madam Chair, I thought a long time ago we should have done that. And to come to try to deal with education, who has 5 pages of amendments, and if Mr. Miller succeeds, that's another 2 pages. 7 pages, about 8. I got 23. And it is a huge bill in itself. I mean, really, you can only consume so much. I mean, I know that, lawyers like you all can do all kind of things, but I just find that we're not making the headway that I would like to make in understanding the whole, some of it. I think just put it off till Monday. I mean, you can pull back the election bill, Pull that back and put that until about Monday, next January.
Member from Easton.
Madam Chair, I believe that it is reasonable to shut down soon. I don't think that and Monday, certainly we will only have the 1 or 2, whichever the Premier decides now. But certainly people can. It is unconscionable to expect people to routine all this at this stage, especially the chair and the clerk. The staff is and the chair and the clerk, I think, is more so than the rest of us. I mean, these things are piling on us, and the repetition of every second having to say the same thing, it has to be brain draining.
I'm so grateful, member from Easton, for your kind consideration, but I've already missed my BRAC flight, so unless you can make other arrangements, I'm open to the committee.
Madam Chair, I have filed a number of amendments to the election.
Member from from Northside, sorry.
Yeah, I have filed a number of amendments to the election law. I won't be here on Monday because I'll be attending the Public Accounts Committee conference in Kingston. But I can leave those in the worthy and capable hands of the member for East End, and just to put members' minds at rest, I did meet with don't jump up and down too early, with the Minister of Education this morning, and they have incorporated all except 2 of the amendments that I have filed into their amendments that they're filing. So, Madam Speaker, if you will allow, and the committee will allow, I will at this time withdraw, although we're not dealing with it, but with permission from the House, and I won't be here on Monday, I will withdraw the amendments to the education bill which I have filed, if that's in order.
Member from Northside, you can, well, not you can, but may I suggest you get your colleague to withdraw, because we have not yet come to that. Thanks. Honorable Premier, do you?
Madam Chair.
Honorable Premier, and then the Minister of Education.
She's outvoted, going home.
Madam Chair, I would suggest that let's try to finish the elections.
Tonight?
Because there's only one amendment to it.
Only one, but he don't say that. This can take some explaining. Yeah.
Okay.
I think you leave it till
well,
Monday. Yeah.
Fine, Madam Chair. I'm not gonna fight them. That's fine.
So, Madam Chair, sorry, just
Honourable Minister for Education.
just for clarity then, so because we haven't dealt with the education bill tonight, the member from East End will do the formal withdrawal of your amendments then when we get to the bill? Okay. Yes, and I thank you for definitely, showing the reasonableness in that regard.
Honourable, sorry, I recognize Honourable Deputy Speaker. I beg your pardon, sir.
I appreciate your joining, Madam Speaker. I went in the fridge just now to try to warm up, and my toes and my feet, I don't know which one it is. So, if it continues, I won't be here.
Honourable Minister of Finance, I think you found a source for some savings. Honourable Premier.
Madam Chair, I am one that is always slow to quit, but I know when people have had enough, and there's just no way we're going to get proper scrutiny of the bill, as important as that, after 9 o'clock on a Friday night. We've been at this since 11 o'clock today. So.
Can I get a motion for the adjournment, sir? The House will now adjourn until, the committee will now adjourn until 10 a.m. on Monday morning. And we will come back to committee. Thank you. Have a safe weekend, everybody.